Next up, not since Jordan and Worthy went to the NBA has there been a North Carolina tag team like the next two. We've got Jim McLoughlin and John Fagg of Moore and Van Allen's Charlotte office. Jim has extensive litigation and arbitration track record that includes arbitrations before the old NASD, NYSE, AAA, and the ICC. Trials and appeals in numerous state and federal courts and international matters. He has represented clients in responding to and defending investigations by the SEC, FINRA, DOJ, CFTC, North Carolina Attorney General's Office, UK FSA, I have no idea what that thing stands for, but he's been there, the Monetary Authority of Singapore, and others. John is no slouch either. In addition to being an experienced trial lawyer, he has extensive experience in conducting internal investigations and representing clients in domestic, international, and cross-border regulatory enforcement and white-collar defense matters. He has represented clients in regulatory, enforcement, and criminal matters involving the SEC, CFTC, the DOJ, the FDA, and other organizations known by their own initials. Please welcome Jim and John.
So we thought we might have an extra microphone, but we don't, so we're going to just stand up here and do it this way. You have the cue controller. Just by way of general introduction, what we have seen in the last several years, and most recently in the last two, is the government taking a very different perspective in the means and methods it uses to pursue financial crimes. And so we're talking about insider trading, we're talking about basic misrepresentation, we're talking about abuses of confidential information. And so what we've done is we've taken a look at a number of the recent cases, including several that we've listed here, Thomas Strickland, Robert Ramnarine, Rajat Gupta, very famously, and Raj Rajaratnam, and of course the current case pending against SAC, Capital Advisors. And what you're seeing now is what we've all expected for a long time, which is the means and methods of the drug wars are really working their way into the financial system. And so if you are either an organization that has people who are susceptible to these issues, for example, you have analysts, you have brokers who are talking to people who have confidential information, you have some very serious issues, as for example, if you read the SAC indictment, you'll see that much of that indictment is built around SAC's failure to have compliance procedures. The government is also pursuing some aggressive theories in court. For example, you don't need to have a personal benefit to have an insider trading case. Now the Second Circuit, we'll see, said, oh yes you do, but it's so small that it's hard to say that they've actually found one. In fact, the Second Circuit said the bar's not very high. Also, issues of implied harm, the ability of the government to argue implied harms and therefore get over their burdens. And this fundamental notion that you saw in the Rajaratnam case and you're seeing in SAC, that what some of us might have called and some financial institutions would call networking and sophisticated analyst work of going out to people in the field and doing that nuts and bolts work is in fact the basis for an insider trading case. And so there are some things that you can be thinking about in terms of avoiding those problems when you're both defending these cases and you are thinking about the compliance procedures that your broker-dealer or other financial institution would have to have. So we're just going to very quickly summarize some of the cases we're talking about and a couple of others. So Thomas Strickland, which is the U.S. v. Obis case, is one of the seminal cases. Strickland is an employee of GE Capital who is working on some acquisitions. He tips a college buddy about what he's working on, who works at a hedge fund. His college buddy then tells his boss Obis. Obis trades. The SEC pursues all three of them. Strickland says, I didn't get any benefit. I was just talking to a friend, and you really can't come after me. That goes to the Second Circuit. The Second Circuit says, well, yes, you do have to establish a personal benefit, but again, the bar is very, very low, and for purposes of summary judgment in the case brought by the SEC, the fact that you are college friends is sufficient for us to presume there is a benefit to get past summary judgment, which means you're going to trial. And if the bar is that low to get past summary judgment, then Strickland becomes a critical case for the government in pursuing those kinds of cases. Robert Romnerine is much more of a classic case. He is a basically pension benefits supervisor at Bristol. They're doing a number of acquisitions. He rises through the ranks. And the importance or the significance of Romnerine is he trades on a number of potential targets, and there the government uses a lot of data mining techniques in terms of going into Bristol systems, going into their network, his laptop, to get a lot of information that they ultimately use against him in pursuing that case. He ultimately pleads guilty. Also, what's interesting about that is they pursue both a civil and a criminal case in parallel, giving themselves, in effect, 2 bites at that apple: criminal forfeiture, civil forfeiture, and so the defense of those cases becomes considerably more expensive as well as sophisticated, because you've got the civil discovery on the criminal discovery issues going on at the same time. Next, very quickly, and maybe most famously, is Gupta and Rajaratnam. Gupta, you will recall, is a friend of Rajaratnam. He had invested with him. He was a former senior guy at McKinsey. He is, part of his defense is that I really didn't benefit. The information I provided was abused. In this case, again, key here was wiretaps, people wearing wires, and the government, again, coming into kind of a roll-up philosophy. Let's start at the bottom with analysts and salespeople, and let's pressure them and work our way up. And both on the criminal side and the civil side, on the civil side, you're thinking about the new SEC cooperation initiatives and its program. The first 2 announced cases in that are 2012, which is going to create another pressure point for people who are potentially involved in these to go to the SEC early and say, I want to help, even, of course, while they're participating in the defense. And then lastly is the current pending case against SAC, in which, again, if you read that indictment, they take the number of insider trading cases, some still pending, some subject to pleas, involving SAC analysts and portfolio managers. Then they go after SAC and its people basically on the principle that this was your modus operandi of doing business, and one of the ways we know that is, despite some red flags, you had absolutely no compliance procedures that were effective in going after these. And again, there we see a tremendous amount of data mining out of computers, wiretaps, people wearing wires, and again, this roll-up philosophy. We're going to get your managers, we're going to get your advisors, we're going to get the cooperate, and then we're going to pressure you.
Thanks, Jim. And to touch on some of the issues and the theories that Jim mentioned earlier in a little bit more detail, and to follow up on the last presentation, I mean, what we have clearly seen over the last year and even more, and a trend that is continuing, is an increased number of enforcement actions, an increased number of prosecutions for these type of actions. And so whether it's FINRA or the SEC, the DOJ, or state AGs who are taking these actions, they clearly have their targets set on the professional class. And so whether that's brokers, lawyers, doctors, this expert network, compliance officers, everyone in this room, I think, probably is in the focus here, and we see no indication that that's going to let up anytime soon. And in addition to having the focus on these folks, they have started to increase their theories or widen their theories of liability. And so with respect to the information duties, while the government has typically said that the federal law imposes the fiduciary duty and that they can show a breach of a fiduciary duty in these claims, the reality of it is that that's not a battle that the government has to win. You can look at the case against Mark Cuban, which went up to the Fifth Circuit, where they said that a confidentiality agreement that Mark Cuban had was breached, and therefore he had the had an enforcement proceeding brought against him by the SEC. So we'll see what happens. He's scheduled here to go to trial very soon, and we'll see what happens there. But all of the government is trying to expand their theories of prosecution, while at the same time the courts are allowing a relaxation of the requirements to show, in particular, inside trading. And one of the principal ways that the cases have seen and shown that that's being done is through the misappropriation theory, to say that people misappropriated inside information. And then the other is an affirmative misrepresentation, which is not historically how the government has tried to prosecute or enforce these types of cases. And also, what Jim mentioned in the Second Circuit and also in the 11th Circuit is the issue of personal benefit. And so the government, or the courts rather, have held, yes, there still is this requirement to show that you were personally benefited from the action that is involved in insider trading. But the reality is that the court's definition of personal benefit, and I think what certainly we had always understood personal benefit to mean, are two entirely different things. In the Strickland case, it was that you were seeking to do a favor for your college buddy. In an 11th Circuit case, it was extremely similar to that. It was to, quote, continue to maintain good relationships with the tippee. And so it's hard to imagine, other than perhaps a communication or a tip to a complete stranger, where the government couldn't at least allege that someone was trying to maintain good relationships with the tippee. And so the network there, or the scope or the dragnet there, really has broadened quite considerably in the last year and a half. The issue of implied harm we've seen in all of the recent high-profile cases. The government has made very little effort to try and show what the harm was from the supposed insider trading that happened. And the Delaware Court of Chancery on the civil side has supported that. They have said that in a shareholder derivative case, that the plaintiffs there don't even have to allege that there was any harm. All they have to do is show that there was insider trading, and therefore the harm is expected to have happened. And so in terms of the requirements that the government has to show for these types of cases, they keep getting knocked down and knocked down and knocked down, which has real implications for all of our clients, whether we're outside counsel or inside counsel or compliance personnel. And then the issue of networking as a violation of law here. In the financial industry, in the pharmaceutical industry in particular, and then also as it relates to anything that's subject to ongoing legislation, particularly in Washington, we have seen a continued and a tightened focus on these networking opportunities and these networking relationships. Things that were permitted in the past or that were not closely scrutinized are now being scrutinized extremely closely. Jim mentioned the Galleon case, and the SAC case. Both of those I think are probably the most high profile of these matters, but there are a number of them that are moving forward in U.S. attorneys' offices and in state AGs around the country. And essentially this paying for information is continuing to be more closely scrutinized. I think we'll continue to see that even more so on the side of Congress, where people are trading ahead of legislative action and trying to determine what's going to happen, how that legislation is going to impact particular companies and particular markets and individuals paying to get that information ahead of time.
And you also see that each of these things individually is less significant in the way they are interwoven. So, for example, if you take the Second Circuit's recent Apuzzo decision, where the issue there was, for an aiding and abetting liability, does the SEC have to prove that your, quote, assistance, close quote, was a proximate cause of the violation? Second Circuit, not unpredictably, said no. Goes back to the classic learned hand test. All you had to do was, knowing of the conduct of the principal, appear voluntarily or otherwise to provide assistance so that the conclusion can be drawn that it was something you sought to bring about. If you take that relatively relaxed standard for aiding and abetting and you tie it into some of these networking cases, providing information to your buddies, then the pressure points that the SEC or the Department of Justice has, either to say, you know, this could happen to you, or you can join our voluntary cooperation program, you know, you see where that's going. 2012, you have one of the first SEC cooperation cases in Cindery. In Cindery, you may recall, is an individual who gives false information to auditors about the health of his bank. The SEC begins proceedings. He is a principal participant in that he affirmatively makes misrepresentations and alter documents, but the SEC nonetheless allows him to participate in the cooperation program, gives him a pass. He is not charged civilly, and that is then used, of course, against a number of other people. So when you put these in combination, what you see is an broad increase in the tools that they have. Again, the classic, you're going to get your 5K in the criminal case, or your Rule 35 motion that you're going to get credit for cooperation, both on the civil side and, you know, with the SEC, and on the criminal side, gives them a lot to work with these more relaxed definitions.
I think to circle back on a couple of other things in terms of the use of the tools from the drug wars, in particular wiretaps and informants, there was always the belief that in the drug wars it was easy to get wiretaps because it was easy for the government to demonstrate that they couldn't get at the information that they needed without exposing the public or the law enforcement agencies and personnel to significant amounts of danger, and so they were able to apply to the courts and get wiretaps on a regular basis. And traditionally that didn't happen in white collar cases, and now we're seeing it across the board in insider trading cases. We're seeing it in public corruption cases, and we think that that is only going to continue. The government knows how effective that evidence is, to be able to have someone's own statement, to have the defendant on the tape saying something that, if we all think that emails and Bloomberg messages and text messages can be taken out of context, certainly something that you say on the phone casually to a friend, it can very easily be taken out of context, and we saw that in both the Galleon cases and in the Rajat Gupta case, and that is absolutely going to continue. Jim mentioned earlier the leveraging of informants. I think everyone needs to expect that the government will continue to put a great deal of pressure on the lower level actors here to try and ratchet things up, which means that people who are involved in investigations should expect, if you have the Department of Justice or you have a state attorney general's office involved, they should expect that the FBI is going to come see them. And it doesn't matter if they're represented by a lawyer or not. The FBI is going to show up at their house, and they're going to show up at dinner time when they're there with their kids, or they're going to show up on the weekend. They're going to show up at their kids' schools when they think that they're picking them up. And we'll try and use their power as leverage to get people to roll on their superiors.
We had one case together where it was a state AG's investigation where it had gone on for months. The state AG referred the case to the Department of Justice, U.S. Department of Justice, for a number of reasons. The FBI and an AUSA showed up at our client's house wanting to chat. We, of course, called, when we found out about this, we called ballistic that they had gone to speak to a represented individual. And their response to us was, well, that was a state investigation. We didn't know that he'd be represented by you in the federal investigation. So you should not expect, and that's the kind of stuff in the drug war, you know, you just say, sure, it's Tuesday. But that is the kinds of thing that you're going to have to expect.
And I think that In terms of the takeaways from this, it's that we all, those of us that are lawyers, those of us that are compliance personnel, those of us that are in business supervision, or those of us that are in senior management from businesses, need to understand that businesses are being held to a higher standard, that you are under more scrutiny, and there's very little appetite or willingness at the government to hear you out on why you should be treated differently, or why things that have always been done the same way are okay. I think that Judge Rakoff said it well in a recent sentencing that he's had, where he said, "I find it very curious that all defendants only realize how much they love their family and their friends after they've committed a crime that subjected them to this punishment." And we see that time and time again in these matters. So, thank you.
Thank you.